So we'll call the meeting to order at 6 p.m. And Mr. Tate, can you do roll call, please?
Yes, Director Bockham,
Here.
Director Reed,
Here.
Director Marshall,
Present.
Director Whiff,
Here.
and Vice Chair McNerland.
Present. And before we go any further, would you guys mind standing for the Pledge of Allegiance? I
Pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Okay. So the first, just before the public expression, I want to recognize our 3 new board members and congratulate each one of you. There's no glory, there's no fame, and there's no money in this job. So thank you for volunteering and going through everything you have to do to be here. And I think we are all looking forward to working with each one of you. Next we're going to open it up to public expression. If anyone would like to comment on anything that is not on the agenda, now is the time. You could just come to the podium and state your name for our minutes. I'd appreciate it.
Good evening, board. My name is Dan Buffalo. I'm the finance director for the city of Ukiah. I just have 2 remarks I'd like to make. I know you're going to be very busy tonight and you have a lot on your plate. The first is just to introduce myself and offer the same offer, for lack of better terms, I made to this board a year ago, and that is that my door is always open. I'm available to all of you and to the board as a whole for any information you may have or requests for information you may have, questions you may have. Please feel free to contact me. Mr. Tate has my contact information, but my card is here as well, and I'd be happy to share that. But please, I'm reaching out, and I hope that you would reach out as well. And then please feel free to ask me any questions you may have about the finances of the city, how we manage the district's finances on our books, and anything related to that. The second item I'd like to just briefly remark about, knowing that you have a lot to do, you're very busy, and there's a steep learning curve to try to be brought up to the happenings of the district currently. We have a tremendous opportunity right now to do a lot of good for this community in the sense of we have $60 million in outstanding bonds that we can possibly refinance. We did some analysis, and we have 2 opportunities every year to do a refunding, what they call a refunding, which is a refinance. We're in the middle of one right now. The problem is that we expect a rate hike from the Fed in March, and that would be after this current window expires. What's at stake for us is possibly $3 million of interest cost savings. The City Council last night authorized me to start putting together the team to prepare for a bond issue, but this is just the mechanics of the issue. So bond counsel, financial advisor, underwriter, that sort of thing. We're going to be on standby waiting for direction from the council and this board on what it would like to do, what the 2 bodies would like to do. The mechanics are really just in the backdrop. What we really need is input from the board and the city council as to what kind of refunding they want. Right now we envision just a straight refi, similar to refinancing your house. You're just trying to get a lower interest rate. But there might be other considerations both this board and the city council want to explore together. So timing is of the essence. We have a little less than 2 months to have a deal in place so that we can notify current bondholders that we intend to refinance. That date is January 30th, so we're operating a pretty tight window, and again, we don't want to put a lot of pressure on you, knowing that this is your first meeting and you're trying to get caught up. There's a lot going on, but I just wanted to put that out there and let you know that we're on standby waiting for this board and the city council to give us further direction. Again, regarding that issue, please feel free to contact me, and I'd be happy to talk about the mechanics of what's involved in a refunding, how we arrive at those estimates of potential savings, and anything in between. So thank you.
Yeah, absolutely.
Yes, please.
Do you have any kind of prospectus or any kind of proposal created at present for this?
I do have one in draft. I'm working with our financial advisor who has done the analysis on what the market condition is right now and what we are likely to realize in savings. But I'd be very happy to share that with this board if it wants to have it on the agenda, and I can come back and discuss that. But we do have that information in development right now.
Thank you.
Yes.
Thanks to you and Sean and Jared for your partnership so far. My short time here.
Yeah, it's been a pleasure. Thank you. All right.
Thank you, Mr.
Thank
Flynn.
you.
And Mr. Tate, are you on top of that with him?
Yeah.
Okay, perfect. Okay. Is there anyone else from the audience who would like to address the board?
Yeah, I could. I'll make it short. My name's Don Crawford, and I'm a ratepayer of the district. I want to thank Ms. McNerlin for the gracious welcome you gave to these new folks. I know they're diving into something that has obvious and hidden complexities. I'm quite confident that the constituency of the district are very, very thankful that they're brave and competent souls that took on the challenge of embarking on this new position. And I'm sure that the district, the ratepayers, everyone, in addition to being grateful, are lucky. Thank you.
Thank you. Any other public comments?
I'm David Radford. I'm the Ukiah City Attorney. I wasn't going to say anything, but since Dan brought it up, the elephant in the room is the lawsuit that the district has pending against the city. That refinancing will not go through unless the lawsuit has been resolved, because the bond counsel can be able to represent to the purchasers of those bonds that there isn't a possibility that the litigation could affect the viability of the bonds. And that would make, the pendency of the lawsuit is going to raise the interest rate and make attracting an underwriter or attracting a bond insurer very difficult.
Thank you, Mr. Poe. Anyone else? No? Okay. We'll close public expression now. Item number 3, discussion and possible action regarding selection of Ukiah Valley Sanitation District Board Officer. So to start off this item, I would like to recognize Director Whip because you got the most votes. So, do you have any discussion on this item or wish to make a motion?
I would like to defer to the rest of the board. I would like to see you in place for the interim if you were willing. I don't feel as though I'm up to speed,
Would that be a motion then?
yeah.
Okay, thank you. I appreciate your confidence in me. Thank you. Is there a second to the motion?
Sure. Well, you know what? I won't. I'll allow someone else to second. But I would like to add a comment that organizing a board is challenging, not just in the dynamics, but I mean following the structure of a meeting. And I know Teresa's done it for quite a while, and very familiar with it. So it would be a good choice.
Andrea's also done it and would feel confident in doing it if you didn't want to do it. So there's lots of possibilities, or 2 possibilities.
Yeah. and
So we
then
do, I'm sorry, but according to procedure, we do, in order to discuss this, we have a motion on the floor and we do need a second in order to discuss. So if there's not a second, the motion fails and goes away, or we get a second and continue to discuss.
I'll second.
Thank you. There's been a motion and a second. And now it's open to discussion.
Yes, I would like to, I would like to see Andrea, you know, a new perspective, someone to take over the board as in a leadership role. She has a lot of experience, and I just feel like we need to move forward quickly, and she has a lot of energy, and so I kind of wanted to nominate Andrea. So I don't know how that works, if there's already a motion.
So how that works is, the motion now belongs to the board, so it can't be retracted. And the board would either vote up and down on that motion, and it would either pass or fail. And then should it fail, then a new motion can be entertained by the board. Is there any other discussion on this matter? I would like to say something. That I have been on this board 9 years, and I believe that the chair position, this position is only a 20% say-so. We all have 20% in what happens on this board. And as a position of chair, really it's just to make sure the meetings run smoothly. You do have to maybe meet with Mr. Tate and to iron some things out, so it might take a little extra time. But I feel I have the experience of knowing the Brown Act, of knowing the health and safety codes that pertain to our board, knowing the state laws that pertain to our board, and knowing our parliamentary procedures in order to run a meeting smoothly. I would love to work with someone as a vice chair that's new to the board, if you choose to do that, and share responsibilities. But just to reiterate, the chair is just to make sure things run smoothly, and I just feel that I do have a knowledge that I can help that along, and that I do value the input of everyone on this board, and I will always be open to any communication, any suggestions, anything you'd like added to the agenda. Okay, thank you. Is there any more discussion? No? All right, Mr. Tate, should we do a roll call vote or
I
just?
think under the
Public
Brown Act,
comment.
yeah, give
Public
the
comment.
public a chance.
Public
Absolutely. I'm sorry. See, I'm still a little.
It's okay.
Okay, so is there any public comment on this item?
Yeah, I have actually some more questions. I think the board needs to understand what the specific authority of the chairman is before they make this decision. So that's my question. What's the role that the chairman has? Is it just presiding at the meetings, or is the chairman empowered to call special meetings? Is any other, how are special meetings called if the chairman doesn't call one? How are agendas, how are items put on the agenda? Is that a decision made by the chairman, or is that something that any member of the board can add an item to the agenda? I think those things need to be understood before you make this decision. You know, the election was a pretty powerful election for the challenges in terms of the number of votes they got compared to the incumbents. So there was an expression of some concern by the voters. So I think the new board members need to understand what powers. Is the chairperson the primary contact with the attorneys representing the board when the board's not in session? Or that could be an important role that the chairperson plays, and that other board members need to understand that before they make this decision.
May I? So currently, the chairman can call meetings and call special meetings. Also, 3 members of the board can all request a special meeting. That's something I'd actually like to change to 2 members. I think because 3 members actually consist a majority, and that's actually a meeting for us. That's something I'd like to address as a change to one of our policies, is that any 2 members can request a special meeting. I would hope that whoever is chair, though, if any one member asks for a special meeting, that they would consider that and go to the vice chair and consider with the vice chair as well. I don't think we should feel like we have to have 2 or more people to call a special meeting. That's just kind of silly. The other question is, the chairman does have a signing authority for the board. along with one other person at the Savings Bank of Mendocino. The chairman or chairperson is the point of contact for the attorney's office and the vice chair. So they could meet together with the attorneys. Also, we can't have 3 because again, that would be a violation of the Brown Act, so it would be 2 people or less. One of the things I believe this board should address are our policies and procedures coming up. And a lot of those things can be more strictly defined, however this board wishes. The duties and the roles of the chairman and the vice chair. We've never had a secretary and we've never had a treasurer, but that is also something that this board can consider and implement as soon as possible. So, Doug, did you have anything to add to that?
No, I think you covered it unless there's a specific question.
How about the agenda creation question that he brought up? Who's in charge of creating the agenda and getting the content on there?
Well, I guess ultimately it is the chair, but this agenda was put together through input from several members. I didn't put this agenda together. I think somebody wanted elections and that was placed on the agenda. It was my idea to have Brown Act training. I thought that was important to have on this agenda. Another new member of this board wanted to change the meeting dates, and so that was placed on this agenda. So it was collaborative. It is ultimately the decision of the chair. But with the input of the board members, and the board members, 2 or more, can have anything they want to put on this agenda. But I don't think it should ever be an issue that has to be. I think the chairman or chairperson should be open to putting anything on the agenda that this board feels is important enough to be on there. So,
Are there written policies? Is there actually either a resolution or minutes of meeting where these rules of procedure you're talking about are set forth?
Some of them are. They were adopted back in 2010 by the Sanitation District.
Is it a resolution or?
I'm not sure how it was district policy was adopted.
It just says district policy?
Ukiah Valley Sanitation District policy, rules of the order for board and committee meetings. And policy number.
Is that available on the website?
5070. Unfortunately, we don't have the capability, I believe, to have a lot of stuff downloaded there, but it is available.
If it's an ordinance or a resolution, it may be.
It may be, but I don't believe
on the
it's.
website. But it really, my experience so far has been the management over time has been hit and miss. And so my review of the existing 38 policies that exist, 33 of them need to be brought to the board. I've already started doing that, as you board members know. And when I've written a policy that I think is good enough for public consumption and the board's consideration, I've brought those to the board. There's many others that actually need to be analyzed by this body before they direct me to make any changes. So it's just dependent on the, if it was ministerial in nature, Dave, I've just done them and brought them to the board. If it's more board governance and those issues, that's how to start here.
So we did adopt those because that's what the Mendocino County Board of Supervisors were using. And as a brand new board just starting off, we thought it might have been a little easier than going full on Robert's Rules of Orders. But that is certainly something I'd kind of like to move to Robert's Rules of Orders. I just think it's more easily accessible for the public. There are some things we could change in there in the future that we don't need as a small board, but that's up to the discretion of the board.
Is there still comment?
Yes, sir.
Don Crawford again. It appears to me already that Ms. McNerlin has a little different approach than the previous chairman. In my impression going on through the meetings that I've attended in the past, I had the feeling that the chairman was either through a connection with the lawyer's office or whatever, that there was an undue influence. That's just my impression. That's not an accusation over the board. It would trouble me that, well, with the mandate, the voter mandate and everything, it would trouble me if a previous board member was the sole contact to the attorney. I think, and if the chairman is gonna have that position, it was a troublesome relationship as I witnessed it, because I knew that the chairman cohabited the building that the attorney was in, and I don't know what influence there was there or if there wasn't. The other thing is the signature power for payment requests. That's another, it seems like that's a very powerful position. I don't know what the rules are, whether two board members, a new member, like a vice chair, and the chairman could share that role rather than have just the chairman and say a manager or something do it, because there were some, I mean, I'm gonna be honest here, there's definitely some relationship between approving and being able to view proper documentation for issuing checks. I'm not totally confident that the last process was as transparent as it should have been. So there are still some lingering questions there. And I'm in no way equating your approach to how this board runs compared to the previous chairman. I'm just saying those are questions that I think need to be addressed and analyzed a little bit. Thank you.
And to follow up with that, this isn't a reflection on you. I would like to see you in the vice chairman position so that you can mentor one of the newer board members, because we had a lot of problems with the previous board, and we're still, you know, I would like to see someone fresh in there that has a whole different perspective, and that's why it's nothing personal.
We're still open to the public for public expression. Is there anyone else? And I don't want to limit anyone, but please know that we have about 2.5 hours of Brown Act training in front of us.
Good evening, Leon. Well, I do have a couple things right off the bat. One is, you know, it takes 3 votes here to do anything. You'll learn that tonight if you're going to go through the Brown Act. 3 votes, no matter what you do, whether you're going to make payments, direct the chair to pay, whatever. That's the reality. The only time that I know that it is acceptable for the board members to meet and not have a Brown Act violation is to 3 board members can set a meeting. That is in the Brown Act. Anytime they want, they can get together and designate that the board will have a meeting. Most of the time, it's left to the chair to call it. But don't get paranoid with this idea that one person is going to run this thing. You have the power and the authority here to make sure it runs the way 3 people want it to be run. So, you know, I came here only one time in the last year, and I asked for records. And I got the records. And I went through them, piece by piece. I didn't find any discrepancies in the payments and how it was paid and how it was authorized. Even though I attended the city council meeting, and I thought this place must have been anarchy when I came down and asked for that. So, again, move ahead, get your feet on the ground, and try to make this work for the citizens. Thank you. Oh, by the way, your last sentence in your thing, I just always have to bring it up. Anyone wishing to speak must come forward to the podium and state their name. No, I don't have to state my name. The Brown Act says I don't. Thank you.
But I know your name, Lee Howard. Are there any other public comments at this time? No? Okay, so we'll close public expression. Any other board discussion?
Just reiterate that the process of running a meeting, especially with issues that can be contentious, and it's really good to maintain a level of order. And I do believe someone who has sat in that seat previous would be an advantage. Regarding the check, is it policy just to have the one person sign, just the chair, or is it possible to have
Well,
two signatures?
Well, it depends on the amount. The lower amounts,
Mhm.
up to a certain amount, as you know, the board has given me ministerial authority to sign pay bills, those type of things.
Mhm.
Anything of a large nature goes to the chair, and that's the chair's,
Just the chair?
the way it sits today, correct me if I'm wrong, Doug, I think it's just one signature today, correct?
It's one signature on the check,
On
but
the-
generally, the chair is authorized by the board to sign it.
And also, somebody brought up the issue of somebody brought up the issue of accounts and banking and stuff. Right now, there's 3 names, I believe, on the new account at the savings bank that the board authorized, and that was the former chair, Director, Vice Chair McNerlin, and myself to do banking.
Mhm.
I don't do any banking for the district because I've always believed in the hands-off. So, Chelsea does the banking on a day-to-day basis for us, and anything of a large nature goes to the chair. So that's the process today that happens.
But a check can't be cut unless there's a board agreement, is that correct?
A large check.
Right.
Yeah. The day-to-day bills and stuff like that.
What's the limit?
Pardon?
What's the amount limit?
I think it's $5,000.
Policy was brought before the board a couple months ago.
Yeah, I think it's $5,000. I think anything under that, then it's all on the ledger anyways.
Mhm.
But the fact is, anything under that, I have the authority from the board to sign. Anything over that goes to the chair.
Goes to the board to be approved, then the chair decides.
The chair, and the chair historically, that's been the process before I got here, so that has not changed.
But it takes prior board approval.
The only thing that's changed since I got here was the fact that we didn't have I think the limit for the previous manager was like $500.
I'm sorry.
I think that's the only thing that's changed.
Mhm.
Sounds like there's a lot of interest in this, so could you just make a note to put it on our next
Yeah.
agenda, if that's okay with everyone? And let this new board make a new policy or
Yeah,
revisit what the policy is, and we'll move forward from
I
there.
think there's that's a part of another discussion, a bigger discussion we need to have, and Doug has a list of things that, just the board rules and protocol, and all of those things, whether it's Robert's Rules of Orders or what we have today, we need to go through that with the board.
Yeah, I just don't want
So
to
they
get
understand that.
too off the agenda at this point,
Yeah,
so,
yeah.
let's put that on the nearest possible agenda for this board. Thank you. Is there any other discussion regarding the selection of the chair at this point? No other discussion? Okay. So Mr. Tate, why don't we do a roll call vote, please?
Okay. And the calling the question is Director Whiff's motion,
Yes,
and seconded by Director Marshall.
correct.
And that is to maintain you as the chair moving forward.
For this one
That
term.
was your word, and
Yes.
maintain Teresa as chair. Okay. Call for the
Now,
question.
is that your interest?
Yeah, I would be willing to do that, yeah, for one term. For
What is
one, it's one year, 1 year. And then hopefully we can get someone, okay, thank you.
Okay, Director Whiff,
Yes.
Director Baucom,
No.
Director Reed,
Yes.
Director Marshall,
Yes.
and Vice Chair McMillan.
Yes,
Congratulations.
thank you. Thank you for your support.
Now, then I would nominate Andrea as the vice chair If she's willing,
And that's a making of a motion, correct?
yes.
Okay.
Okay, so there's been a motion, as Director Reed for the Vice Chair of the Ukiah Valley Sanitation District. Is there a second?
I second.
Dr. Bachman, second. There's a motion and a second. Is there any public discussion on this item? Any public comments? No? We'll close public comment on that. Is there any board discussion? No? Okay, roll call vote please.
Director Whiff,
Yes.
Director Marshall,
Yes.
Director Bacham,
Yes.
Director Reed,
Yes.
and Chairperson McNerney.
Yes. Thank you.
Unanimous.
Congratulations.
Great.
Okay, item number 4, discussion and possible action regarding selection of date and time of regular board meeting. It's come to the attention of the board that our meeting times, days, don't work with everyone's schedule. And so I'd like to open this up for board. Somebody have a motion to move this to a certain day or time?
I requested this going off of Director Marshall's comments when this came before the board previously to be moving the meeting to the second Wednesday of the month at the same time.
Okay, is that a motion?
That's a motion.
Okay, there is a motion to move our regular board meetings to the second Wednesday of the month. Just for clarification on that motion, would that begin this month or begin January?
Begin this month.
Beginning in December, so that would be December 13th. Okay, is there a second to this motion?
I'll second.
Okay, there's a motion and a second to move the meeting dates. Is there any public comment on this item? Seeing none, we'll open it up. Oh, I thought you were leaving. I'm sorry.
You go this way.
You were just hoping. Yeah, she was hoping.
I thought you just got bored and were walking out.
The fact that, again, the Brown Act speaks about setting meetings and how you set them and what to do. This organization has 3 ways of actions: an ordinance, a resolution, or a minute order. It suggests that the setting of meetings, the annual meetings for the monthly meeting for a year, be by ordinance. That's not for you guys, that's for the public. So we can sit down when you guys have decided that you're going to do this and you've published it and you let everybody know that those meetings, we can look at our calendar and calendar for a whole year of attending the board meetings if we want to do it or whatever we want to do. This board has been bad about meetings and moving them around and having them. You're talking about a regular meeting now. I would suggest that if you want a meeting this month, again, that you go ahead and call a special meeting. But you go through the process of notifying the public that you're going to be changing your meeting dates, and you publish it, and you come in with an ordinance or a resolution that is done out, so we know what's going on ahead of time, and then you adopt it. The simple fact that you can just move it around isn't in the public's interest. It may be in some people's interest, but I don't think it's in the public's interest. And I believe I even gave the code section regarding this earlier today. I emailed it to the district, but I would suggest that you look seriously, because this is a serious issue. And to make it work, I'm giving you a way to make it work for an immediate meeting. You can call them a special meeting within 24 hours, no problem. Thank you.
Any other public expression? Okay, we'll close public expression. Mr. Loza, can you please address the proper procedure? What's our proper procedure for changing our regular meeting Do we need an ordinance or a resolution?
Or a minute order.
Or
which is
minute
what this
order?
is. What this would be at this point, it would simply be based on the minutes from this meeting. And that is a proper way to do it. You can do it by resolution and you can do it by ordinance, either way you want. If the board wanted to adopt it at this point by minute order and then request that an ordinance or resolution be brought back at a later date to put it in one of those formats, we can do that as well.
Okay, so is there, I'll leave it, it's up to you guys for discussion at this point.
I keep my motion as stands.
I'm content.
Do you have something, Mr. Chair?
I do. Doug, can you refresh our memory? We just did this a couple of months ago. We did,
By minute order.
right, we did by minute order. Did we come back with a resolution or an ordinance following that?
No, we did not.
Okay, I'm just trying to get us all current as to what we did a couple of months ago and what we would do moving forward if the board say choose to do a resolution or an ordinance.
Yes. What's the procedure to institute an ordinance? A public notice in the newspaper? I mean, what are,
Generally, it has to be published, it has to be brought before the board twice for a vote, and then it can be approved.
so it's not a big expensive
It's-
process?
It's not a
No.
big, no. A resolution is usually just as good and a little cleaner and easier, and those are also online, I believe.
Right.
Keep all those online. I believe what Mr. Howard was referencing with the public being able to get it online. And they could, if they'd have to go in the agenda, know which date the meeting was and look at it that way. If it was a resolution, it would say resolution changing regular meeting dates, and it would be easy to locate online.
So what do you recommend to be the best?
That's your decisions. I mean, all three are perfectly legal, the minute order, the resolution, or the ordinance. It's simply whatever the board's preference is for how they want to do it. You know, like I said, one of my suggestions was you could vote on it now, it would become effective pursuant to the minute orders, and then you could bring it back at your next meeting or a couple meetings and have either a resolution or ordinance.
I'd like to throw out an idea, I just thought of, in order to make it cleaner and a little more transparent, maybe as an alternate, we could have our regular scheduled meeting for December. At that meeting, make it a resolution to change it effective January. And then from then forward, we could go with whatever meeting dates you choose. It's neither here nor there. I don't have a preference, but that was just an idea. I thought that would make it a little more transparent to the public.
That's all good. There's no, I don't see are you good with that? We have a motion at present, right?
We do have a motion at present, so.
I stand behind your motion to move it effective this month.
Yeah, we have a lot of business to
We
conduct.
have a
so,
lot to get through, and I feel like there's time-sensitive issues that we have.
If it's perfectly legal, did anybody second the motion?
There is a motion and a second, so the motion does belong to the board. It gets voted up or down at this point, so this is just board discussion. Up to the vote.
I think you could actually accomplish both. Minute order would handle it through
Right.
Director Reed's request through the 13th, and on the 20th at the regular meeting, we'd come back, or the current regularly scheduled meeting on the 20th, we would come back and memorialize it with an ordinance or a resolution.
And just for clarification, that the 20th would be a special meeting at that point.
Right. So,
I don't think
There-
we need to call a special meeting to bring
Okay.
it back.
We can try and bring it back by the 13th as well, if that's the board's desire.
Okay. Is there any more discussion? Can we take a vote? Okay, all in favor of the motion, please say aye.
Aye.
Those opposed, nay. Motion passes. Thank you. Okay, now we're going to item number 5, Brown Act training. So we'll turn it over to Mr. Losak, and I will move it out of the way.
thanks, so.
Okay. This is what's called Brown Act and ethics training. It's ethics training is required by Assembly Bill 1234, which requires all elected officials to have ethics training, which is once every 2 years, and I believe within the first year upon taking office. And as part of the ethics training is Brown Act is included.
Will you explain how the Brown Act came to being? I find that a really interesting circumstance, how that happened.
Yeah.
You can't?
No. How the Brown Act came to be, I haven't looked into the history of why and
I
what
believe it was,
caused
wasn't
to
it
be.
the city council where, and I think it was even Governor Brown, not current Brown, but his father, Pat Brown.
So I think it was 70.
And they were conducting business behind the scenes by having these little impromptu meetings.
Yeah, and I'm assuming that's what.
It was Ralph. It was Ralph.
Ralph
Brown
was
Brown
Act, right?
Yeah.
Okay.
Right. And that's probably on the first slide, I don't know.
It actually says in here.
There's a lot of-
I think his picture's on the first
Yeah.
page, isn't it?
That's
Isn't that
right.
him right there?
I'm not going to find the declares, but we'll get to there. This is required, and it's generally supposed to be close to 2 hours. The way I did the presentation is I want audience participation. I want questions from people. If you have any questions, stop me, ask, give hypotheticals so that everybody is comfortable with all of the material. And I believe all the, yeah.
Clarifying question, are you saying that this training is going to satisfy their requirement to meet AB 1, 2, 3, 4?
Yes.
It is?
Yes.
Okay.
Yep, there's the the regulation says who's qualified to give it. I've met it, met the qualifications, and there's that particular thing. And it says, the rule actually said you have to get it approved by the Fair Political Practices Commission, but what they've changed it to is the person presenting it just has to have read the most, gone to their website, looked at the rules, looked at their opinions within, I believe it's 6 months of getting the presentation. And I have been in contact with them this week about that. So this should, as far as I understand, qualify for their training. And I do have certificates for the board after this.
I knew you would.
Starts off with the Brown Act, meetings, guidelines for meetings, types of meetings that are prohibited, emails, agendas, actions, closed session issues, and then talks about, the next section would be ethics, conflict of interest, prerequisites of offices, perks of office, government transparency, and fair processes. And there's Ralph M. Brown, and it talks about the legislature finds and declares the public commission, boards, and councils and other public agencies in the state exist to aid in the conduct of the people's business. It is intent of the law that their actions be taken openly and that their deliberations be conducted openly. And what's quoted very often in different cases is the next part, which is the people of this state do not yield their sovereignty to the agencies which serve them. The people in delegating authority do not give their public servants the right to decide what is good for the people to know and then what is not good for them to know. People insist on remaining informed so that they retain control over the instruments they have created. And then it defines what a local agency is, which is a city, county, charter city and county, town, school districts, municipal corporations, districts, political subdivision, or any board, commission, or agency thereof, or any local public agency. So it's a very broad definition. Covers everything except the state. As used in this chapter, meetings means a congregation of a majority of the members of the legislative body at the same time and location, including teleconference location as permitted by section 54953, to hear, discuss, deliberate or take action on any item that is within the subject matter jurisdiction of the legislative body. And one side note on that section about teleconferences, it is possible for a board member to appear by telephone, but that has to be included in the agenda when it's posted, and the place where the board member who's appearing telephonically is has to be ADA accessible and accessible to the public in general. So if you're doing it at a hotel because you're out of town or something, you can do it, but you gotta make sure it's completely open to the public.
You also have to post the agenda if you're
At that location, yes. So you post it on your door, you post it downstairs in the lobby, and make sure people know where it's at. Usually not worth the hassle unless you absolutely need that board member.
You can't really use that absent board member to make a quorum.
Yes, if they're there. If they're there telephonically, then they are there. They are a member. They're allowed to vote and fully participate. The majority of the members of the legislative body shall not, outside a meeting authorized by this chapter, use a series of communications of any kind, directly or through intermediaries, to discuss, deliberate, or take action on any item of business that is within the subject matter jurisdiction of the legislative body. And that's pretty much the meat of the whole thing. Is if you cannot meet with more than, in this case, more than 2 members to discuss anything that you could possibly be taking action on or could come before you to decide. And
So if the board had 7 members, 3 members could meet?
yes, yes. If you have an 11-member board, 5 of them can meet without a violation. It's just the majority of them.
I think this is really important because it says communications of any kind. So if I were to email one person and say that says something, and that person were to email someone else, and it was through email one to another, that's a violation.
Yeah, that's called a serial violation, and that's going to be covered in a little more detail.
Oh,
But yes,
sorry.
it is. No, that's fine. Definitely a violation. 3 types of authorized meetings: a regular meeting, special meetings called by the agreement of a majority of the board to discuss a specific issue, and emergency meetings held as allowed in section 54956.5 to deal with emergency situations. Exceptions, and this is what I get questions about a lot. The attendance of a majority of the members of a legislative body at a conference or similar gathering to the public that involves a discussion of issues of general interest to the public or to public agencies of the type represented by the legislative body, provided that a majority of the members do not discuss among themselves, other than part of the scheduled program, business of a specified nature that is within the subject matter jurisdiction of the local agency. Nothing in this paragraph is intended to allow members of the public free admission to a conference or similar gathering at which organizers have required other participants or registrants to pay fees or charge as a condition of attendance. And what this is saying is that you can go to a conference and it can be more than a majority of, in this case, it can be 3 members or more, as long as you don't discuss anything that's going on amongst yourself, anything that you could possibly be dealing with as part of your job on the board.
Or Christmas parties, right?
Right. Anything like that, anything that's generally open to the public, other people can attend. When I was with the county, my advice to the board of supervisors was always, that's great, but please don't have more than 2 of you in any one place, because it just gives a bad impression. It looks like something's going on, even if all you're doing is talking about your kids or grandkids or something. It's better if there's just 2 of you at a place. If there's 3, one of you needs to walk away and find someone else to talk to. Because one of the things I'll talk about here, but a lot more in the ethics portion, is appearance and perception is very important for a local agency of what the public sees. It doesn't really matter that it's lawful what you're doing. It's what the public sees and perceives that can be a problem. You know, I believe it was just a couple of years ago, maybe 5 or 6, in Sonoma County, where they had board of supervisors during their meeting days would generally all have lunch together in one place, and somebody filed a lawsuit saying that was a violation of the Brown Act. The supervisors, the court found that there wasn't, because there was no proof or indication that the board members were actually discussing anything that they dealt with. They were just lunching together, but it just gives a bad impression and it forces the entity to have to defend the lawsuit. The tenets of the majority of members of the legislative body to purely social or ceremonial occasions, provided that a majority of the members do not discuss among themselves businesses of a specific nature that is within the subject matter jurisdiction of the legislative body of the local agency. The tenets of a majority of the members of a legislative body in an open and noticed meeting of a standing committee of that body, provided that the members of the legislative body who are not members of the standing committee attend only as observers. Noticing a meeting. The board must provide proper notice of all meetings. Regular scheduled meetings must post agenda 72 hours in advance. Special meeting must post agenda 24 hours in advance. Emergency meetings must post 1 hour in advance. And exceptions to gatherings, conferences, community meetings, other legislative bodies, social or ceremonial events. Posting requirements. Agendas must be posted at least 72 hours before the regular meeting in a location freely accessible to the members of the public. The agenda shall also be posted on a local agency's internet website if the local agency has one. Content requirements. The agenda should contain a brief general description of each item of business to be transacted or discussed at the meeting, including items to be discussed in closed session. A brief general description of an item generally need not exceed 20 words. Agendas must have enough information to enable members of the general public to determine the general nature of the subject matter of each agenda items to be discussed. And the point of that is just to make sure to give notice to the public of what you're discussing in your meeting. And it doesn't have to go into great detail about all the facts and what the issues are, just this is what we're going to discuss. Agenda must contain opportunity for public testimony, may impose reasonable time limitations, can't take actions on matters raised for first time and public comment if item not on the agenda. And
that would be to allow, if it's brought up, that other members of the public can show up and follow the meeting and contribute.
right. If something comes up, then one of the board members can request that that issue be put on the next board meeting. And that is a basis for me advising clients not to engage too much in back and forth during public comment, because at some point you start getting into a more of a discussion as opposed to just hearing somebody make their comment.
Right.
3 action exceptions in a meeting. 3 action exceptions are discussed in section 54954.2B of the Brown Act. Emergency situations. Doesn't apply to the senior coalition. Need for immediate action. Action can be taken on an item that is not on the agenda if the board determines by a 2/3 vote that there is a need for immediate action that can't reasonably wait until the next meeting. And these are the 2 things it has to have. Issue came to attention after the agenda had been posted. The board must openly discuss the issue during the meeting. And the 3rd one is continuance of items posted on a previous agenda. Number 2 is the one that you would deal with most often, if at all, any of them. And it's, I know it as an urgency item. If an item just came up after the agenda was posted, then there has to be, the process is the chair or a member brings it up to the board's attention, says this item just came up and I want it addressed now, then the facts of why it just came up and why immediate action is needed and has to be taken at that point is discussed among the board members. Then there has to be a vote by the board members at that point of whether or not they're going to hear and discuss that item and make a decision. If 2/3 votes yes, then the item can be heard and action can be taken on it if it meets the requirements.
So that could be like an emergency repair at the.
So a pump goes out at a pump station, you need to process the collection system.
Collection, yes,
Okay.
yeah. And that, depending on what it is, might be an emergency situation, but it depends
Yeah,
on what the
just, you know.
severity of it is.
Context,
Yeah.
right.
Brown Act prohibits serial meetings. What Teresa was talking about. Serial meetings occur when a majority of the directors have communicated about an issue and have developed a collective concurrence. A collective concurrence is developed when directors have either directly or indirectly heard each other's opinions on a topic enough to collectively develop or begin to develop an agreement on an issue. And types of serial meetings. Daisy chain, when Director Samantha calls Director Bob to talk about a project, then Bob calls Director Irwin to talk about it, and finally Aaron calls Director Fred. The majority of the directors have talked about the topic, and a collective concurrence has been established. And then there's the hub and spoke, which is employee Terry calls Director John and discusses an issue to get his opinion with him. Then she calls Director Casey, then calls Director Williams, and then calls Director Ukiah, telling each what the other has said. Then the majority of the board has indirectly discussed the topic without public notice and is therefore a violation of the Brown Act. This is probably, the bottom one is probably what happens most often, and it happens quite often by email. One person sends an email to somebody about a topic, that person sends it to another director, who then sends it to another one, and once you have 3, you're in violation.
Which is why your emails always say, do not respond to all.
Yes, yes.
And your emails are discoverable.
Yeah, yes. Use of email, except as authorized pursuant to 54953, any use of direct communication, personal intermediaries, or technological device that is employed by a majority of the members of the legislative body to develop a collective concurrence as to action to be taken on an item by the member of the legislative body is prohibited. The Attorney General has issued an opinion stating that this section of the Act applies to emails, which makes sense. And Mr. Howard pointed out, your emails are subject to Public Records Act requests. Even your personal email accounts, if you're sending business related to the district on a business or on a personal account to other members, if a Public Records Act request is received, there is a process you have to go through to look at the computer to see what you have that falls within the parameters of what the request is.
Does the district have its own email?
There is.
Do you give each board member their own email account?
No.
District email?
No, they do not have that. That might be something the board might want to look into. My personal policy when I was with the county was I had 2 cell phones, a work cell phone and my personal one. Never did they mix. I would not give out my personal cell phone number to anybody. You wanted to contact me, you wanted to text me, you did that on my work phone, or you contacted me through my work email address. To me, it's just cleaner that way. You don't have to worry about what I said and who's gonna go looking through my computer. Closed sessions require 3 types of notice: agenda, pre-closed session announcement, and post-closed session report of action taken. And then these are some of the categories that you can have closed session items on. This isn't all of them, but it is the ones that you're gonna most likely see.
Pending litigation.
Yes.
I've seen it done both ways, where it just says pending litigation, and then others that say pending litigation and mention subject or.
My understanding of this section is that if it's pending litigation, you need to state the case name and the court it's in and who the parties are. If it's anticipated litigation, then you simply say anticipated litigation and.
Which may never come to.
Right.
There's a section of the Brown Act that's called the Safe Harbor Provision. It tells you how you can list closed session items, how you do it, and if you do it in accordance with that section, then that's deemed, that's safe harbor. You know that complies.
Yeah.
So it's a good idea to look at that when you're putting on the closed session items.
Cut and paste off of what's law and use that language, or at least get the language out of there and then use it.
Just use, and then he can give you the format.
Yep.
How to post it.
You have a question?
No, I'm just holding
Just
my
holding
thumb
your
above my
thumb
heart.
up.
I'm sorry.
And then at the end of closed session, must convene an open session and report on action taken, either orally in writing, specific statutory requirements as to form of report, depending on what you're reporting out. Quite often it's no action taken and then, direction given to staff, but if there is some final agreement or some action that was taken in closed session, that needs to be mentioned in the reporting out. And one thing I don't have a slide for. One of the things that you need to be cautious of in closed session is it has to stay on topic of what was listed in the agenda that you discuss in closed session. You can't go off topic while you're in closed session. Talk a little bit of socializing for a minute or two and doing stuff, but nothing related to any other action. If you go in closed session about one litigation case and one of the directors says, well, after we're done with it, they go, well, I want to talk about two other issues. One is another litigation case, and then another is I want to do this or that. That has to be stopped right then and there and said, the other litigation case, we can note it for closed session for our next meeting. The other thing is a public agenda item, and we need to talk about it there. It is fairly tempting for people to try to start talking about things that really don't relate specifically to what is in closed session and what's been on the agenda. Consequences of violation. Criminal penalties, misdemeanor where action taken in violation of the act. Civil remedies, injunction, mandamus, declaratory relief. Action may be voided following notice to correct, which must be received within 90 days and act on within 30 days. Lawsuit filed within 15 days. Attorney's fees against agency, not individual. So it would be like if attorney's fees were awarded to the person who brought the complaint, then it would be awarded, it would be paid for by the agency, the attorney's fees. And this is just a couple examples. Dozens of local government agencies across Los Angeles County have silenced critics at public meetings, held secret conferences to hash out important details or take other actions that violate the state's open meeting law, according to a Times review of district attorney records. And it goes on to say, responding to complaints from the public, prosecutors have sent more than 50 letters since 2001. I'm sure it's a lot more at this point, warning government officials that they acted illegally. District attorneys' officials frequently threaten civil court action or criminal charges if the violations continue. Though no one has been prosecuted, some agencies have been required to publicly reverse decisions made in secret. Several elected bodies, including the city councils of El Segundo and more recently Lancaster, have received repeated warnings to clean up their act. You know, there are people out there who pay attention to what the public agencies do, even the local ones, and they are making sure that the agency follows all the rules that they're required to.
Does every agency have an attorney present in order to make sure that they are within the guidelines?
Some do, some don't. For closed session, you have to. For litigation closed session, I mean,
Of
it's
course.
litigation with an attorney. You have to have your counsel there. It's required.
Excuse me, he has to be there.
Yeah.
He can be there by phone,
Right.
but he doesn't have to be there. He can be on a conference call and that's legit.
Yeah, no, he can appear by phone. I mean, that's fine.
We should set a training.
And most of the special districts in this county don't have attorneys at their meetings.
No.
Yeah. Like the water districts and so on? No?
Fire,
Fire districts, no. They call only when they need it.
or what?
They call only for specific.
There's 50 independent special districts in this county, and I'll bet you there's only 2 that I can think of right off the top of my head that have attorneys at all our meetings.
And I can tell you the Sand District has had one, maybe partly because when it was part of the, when it was a dependent district, when it was, had 3 supervisors and 2 city council members, there was always.
2 supervisors.
Two
one
su-
city.
oh, okay, sorry. I just bumped it up to 5 people. They always had county council at the Sand District meetings, and then when they became independent, they simply contracted with the county council office, and that practice continued of having county council at most of the boards.
Well, regardless of how the board's composed, I think any special district can request county council.
County council.
Yes. Yeah, and they will do it on an as-needed basis as long as they have the staff to
It's
do
up-
it.
Yeah, they,
And, but I did talk to the current county council, and she said she can do it, but not on a regular basis. I mean, they get a question every now and then and can probably answer it, but the reason they got the county council to stop representing the sanitation district was because they just had too much internal work to do.
you would know that better than me.
Yeah. I was there.
Trey, can you have me spoon, please?
Okay, in San Jose, the mayor and other city council members have violated California's open meeting laws at least 3 times this year, and that was 2017, by discussing policy issues outside of public meetings, jeopardizing public trust and generating concerns about backroom deals at City Hall. City Attorney Rick Doyle said the Ralph M. Brown Act violations, which involved discussions about rent control, taxi cab regulations, and a state minimum wage bill, was unintentional and publicly disclosed when the council members realized their mistake. The city in 2007 was sued by Vietnamese American community group that accused San Jose of routinely flouting the Brown Act. An appellate court last year overturned a Superior Court judgment in favor of the city. The case is awaiting a new trial date. That's the last one.
Flouting.
All right. Any questions on the Brown Act?
I have a clarifying question. A couple slides before, I think you touched upon a international, how to remedy or how to correct the Brown Act, I think,
Right.
violation.
Yeah. If
So-
you get notice from the public that they said there was a violation, you look at it and say, yes, you did.
So how about, can I offer a scenario and see?
Okay.
So let's say that you have a local agency calls a special meeting, and on their agenda, they discuss compensation or salary for an executive pay. And they did it through a special meeting, which would be a violation of the Brown Act.
Correct.
How would you go about remedying that violation?
Well, you would need to look at the statute specifically, and then it talks about,
Yeah. You give them a cure and correct to start.
right, yeah, you would send them a letter, give the entity an opportunity to correct the mistake, to go back and do it over, if it's possible, depending on what the issue is, and then, if they do, then they do, if not, then you can file a lawsuit. If there's a difference of opinion on whether or not the violation occurred, then you would have to file a lawsuit to get it corrected.
So I guess I'll clarify a little bit. So how would you guide this board if they indeed violated the Brown Act by doing that specific thing that I just said? And how to correct that? If you found that they had a Brown Act violation specifically related to the scenario I just said, voting, taking action on executive pay compensation during a special meeting, which violates the Brown Act,
Right.
how would you guide this board to fix that?
To renotice it at a regular meeting,
Okay.
do it again. I mean, that's usually the easiest fix, is simply doing it again, giving notice, correcting whatever violation that is alleged, if you believe it happened, and move forward. Any other questions about this?
The problem comes in the fact that a lot of districts ignore the cure and correct letter to start with. It's just as above their comprehension. And the second thing is there's some real timeline to this stuff. How fast you have to act like a cure and correct, and you haven't explained that to this.
Yeah. Well, must be, action may be voided following notice to correct, which must be received within 90 days, acted on within 30 days of receipt, and lawsuit filed 15 days after that. I mean, that pretty much is the timeline. But, a lot of the reason that, as you say, if it's true that special districts in this county don't respond to cure and correct letters, is because they don't generally have an attorney to go to and ask,
I agree with you.
what do I do? I got this letter, how do I respond? And that's what really should happen, is the chair or somebody should take it to an attorney and say, we got this, what do we do?
That's always a good,
Okay. And so ethics.
That's what, that's what.
A public official has a disqualifying conflict of interest in a governmental decision if it is foreseeable that the decision will have a financial impact on his or her personal finances or other financial interests. In such cases, there is a risk of biased decision-making that could sacrifice the public's interest in favor of the official's private financial interest. To avoid actual bias or the appearance of possible improprieties, the public official is prohibited from participating in the decision. And again, I want to say something I said at the beginning is, for me, the ethics rules are the floor. And that's how I hear it in a lot of trainings, is the ethic rules are the floor, not the ceiling of what has to be done. You have to keep in mind that there's a public perception, you're in a public position. What does it look like if I do this? It's something that you should always be asking yourself.
I have a question. So, as chair, if there is a conflict of interest that you're aware of, and that person removes themselves from voting due to the conflict of interest, can they still have input during the discussion?
They actually have to physically remove themselves from
Depends on the conflict, too.
from it. Depends on the conflict. If it's a real property conflict, if the conflict involves the director's real property somehow, then they are allowed to come back in the meeting.
Well,
But they're usually allowed, they have to
they're allowed
walk.
to speak as a member of the public and protect their own.
Right, they walk out the back door, walk through the front door where the public comes in, and then can address the board as a member of the public. But that's the only, generally they can't do that. I mean, usually for most issues, if you clear a conflict, you go outside and you're not involved in discussions, voting, any of that. And you can't, there is cases out there where the person who had a conflict went out in the lobby and started making comments and, or faces and, influencing his or her fellow board members, and that's not okay.
So for instance, let's say my husband sells insurance and this board wants to get insurance through my husband. I remove myself completely. Would they still be allowed to do that?
Probably not.
No, okay.
No, that's a direct conflict.
Well, that's also potentially a 1090.
It's a
1090, right, and they can't do that at all.
So a board can't make any decisions which would financially impact a board member?
No, the
You
board,
would
if
actually be on
you're on the
board.
board and you have a financial interest in an actual contract that the board has to approve, the agency cannot enter into that contract.
Right.
That contract becomes void
Yes.
if it's entered into where that conflict exists.
Thank you.
There's people that have gone to jail for that one.
Yes, there are. Or people, I was just reading one today where as part of a development deal, a city council member, I think, sold property to a third party who then gave it to the city, and then the city took some action regarding the property, and the city was sued, and the council member had to actually pay the money to the city for some strange reason, and he didn't get his property. He lost his property and his money.
The classic case out of Albany is about a 30-year-old case now, but the city council member sold property to the city, and that was determined to be a violation of 1090. The city got to keep the property, and the property owner had to return the purchase price to the city.
Yeah. So they're deadly serious about the 1090.
I just want to make a quick personal observation and share an experience. I misunderstood the conflict of interest clause and the appearance of it because I was convinced that proximity of an influential board member to a contractor to the board because of the natural influence that close proximity would have, like within the same small office building, with the contractor owning the building, the main character in the board renting from that contractor, and I was corrected. I thought that was obviously, if nothing else, the appearance of the possibility of conflict of interest. I went to the Fair Political Practices Commission, and in an exchange of emails, their reading was, unless you can prove that there was a financial impact by the actions of either the attorney or the contractor or the board member, there is no provable conflict of interest. And so that was their reading, which is like what this says. It's basically financial. It's not a sphere of influence.
Right.
And I was correct because I thought sure that would be pertinent, and it wasn't.
And they all talk about a financial impact on their personal finances or financial interest.
So that's separate from the 1090 issue.
That is separate from the 1090, yes. No, the 1090 is a disqualification. I mean, if you simply can't, the board cannot do business with a company that you have an interest in any way, shape, or form.
And the landlord, a leasehold interest is an indirect interest, which is excluded, but if you have that relationship with the contractor, you have to disclose that at the meeting when the contract's approved, and that has to be in the minutes of the agency.
Yeah, and that could be a situation. I don't know. But.
Let's see. basic rule, a public official at any level of state or local government has a prohibited conflict of interest and may not participate in making, or in any way use or attempt to use his or her official position to influence the governmental decision when he or she knows or has reason to know he or she has a disqualifying financial interest. A public official has a disqualifying financial interest if the decision will have a reasonably foreseeable material financial effect distinguishable from the effect on a general public, directly on the official or his or her immediate family, or any financial interest described in subdivisions C6, A through F of the regulation. Is it reasonably foreseeable that the governmental decision will have a financial effect on any of the public officials' financial interest? To determine if the financial effect is reasonably foreseable, apply Regulation 18701. If the answer is no, there is no conflict of interest under the Act. If the answer is yes, proceed to step 2. And I believe, tab 6 in your packets has has 18701. And this just walks through how you can look to see if a financial effect is reasonably foreseeable. Will the reasonably foreseeable financial effect be material? To determine if the reasonably foreseeable financial effect is material, apply Regulation 18702. If the answer is no, there is no conflict of interest. I don't know if I concluded that one. I don't believe I have that one. Notwithstanding Regulation 18702.1 through 18702.5, the financial effect of a governmental decision is not material if it is nominal, inconsequential, or insignificant. And then step 3, can a public official demonstrate that the material financial effect on a public official's financial interest is indistinguishable from its effect on the public generally? To determine if the material financial effect on any of the public officials' financial interest is indistinguishable from its effect on the public generally, apply Regulation 18703. If their answer is yes, there is no conflict of interest under the Act. If the answer is no, proceed to step 4. If after applying the 3-step analysis and determining the public official has a conflict of interest, absent an exception, he or she may not participate in making, or in any way attempt to use his or her official position to influence the governmental decision. To determine if a public official is participating in the making, or in any way attempting to use his or her official position to influence the governmental decision, apply Regulation 18704. The public official will be called upon to participate in the making, or use his or her official position to influence a governmental decision in which he or she has a financial interest as determined in step 1 through 3. He or she will have a prohibited conflict of interest. And the one thing I want to point out is it really is the public official who makes the determination. The attorney can advise you. You can call up or contact the Turf Political Practice Commission, and they will give you an opinion on whether they think you have a conflict. But it is the elected official who has to make the decision. I'm not voting in this, I have a conflict of interest. Nobody can force them to not vote, because are difference of opinions. People have different opinions on what makes the financial interest and whether it's substantial or not. And if the elected official decides that they don't think it is and they want to go ahead and vote, they can vote. Then they have to face the consequences if it's determined later that it is a violation.
So it's not on the shoulders of the board if it is a violation, it's on the shoulders of that individual?
It is, but it affects the board's action. I mean, part of it could be declaring the action null and void. It could affect what the board did or tried to do, but it really isn't, there's nobody on the board who can say, you can't vote on this. You have a conflict of interest. It's like, well, no, I don't. I don't think I do. You read it differently than I do. And then they can vote, and then you just, if a member of the public challenges it, then you have to, it's fought in court. Exceptions, notwithstanding the provisions of sections 87-100 and 87-103 in this regulation, a public official may make or participate in a governmental decision in which he or she has a prohibited conflict of interest if the provisions of section 8701 and regulation 18705 apply. Public general exception. A public official is not disqualified from a decision if the effect on the official's interest is indistinguishable from the effect on the public. Legally required to participate. In certain rare circumstances, a public official may be randomly selected to take part in a decision if a quorum cannot be reached because too many officials are disqualified under the act. And actually have that.
I have never heard of that.
Here.
Oh,
It's a draw on the straw. Can get you there.
Right. I had that in the packet.
public official.
But there can be, if three members have a conflict and you only have two left to vote, and it's something that has to be voted on, then you can, out of the three of them, they draw straws to see who's going to participate, and that person participates. To determine if an agency may segment a decision in order to allow a public official to participate in a governmental decision by removing from consideration the elements of the governmental decision in which the official would otherwise have a prohibited conflict of interest. Apply regulation 18706. But there are times where the government, where the entity wants to or needs to let the other person vote or have a third member vote, and so they can try to remove part of it, and then you have to look out at that regulation to determine, can you segregate it out, separate it out, and so they can vote on that part and not this part. Is it really distinguishable? It reminds me of entities who try to split contracts to come under the minimum requirements so that they don't have to go out to bid. It's kind of the same thing. Can you segregate it out? As Mr. Howard knows, that's not legal or.
We'll sue you.
And then other ethics laws pertaining to, including but not limited to, limitations on the receipts of gifts, honoria, misuse of public funds, prohibitions against gifts of public funds, mass mailing restrictions, prohibitions against acceptance of free or discounted transportation by transportation companies.
Wow, I have sat 9 years on this board and never received one gift.
And you don't have to worry about it. And the gifts include all kinds of things. I mean, ticket to the theater, baseball games, food, depending.
Crackers and cheese.
A gift is any payment or other benefit provided to an official that confers a personal benefit for which the official does not provide goods or service of equal or greater value. Two separate gift limits. Gift limit is $420 annual price.
$470 now.
It is, I was just gonna say, it's gone up. And then the lobbyist gift limit, I don't know if that's changed. I don't know whether we have a whole lot of lobbyists in this county.
But this applies to the state, correct? I mean, throughout the state,
Throughout the
legislatures and stuff.
Yeah.
Different one for the state legislators, they have some different rules.
State work.
Of course they do.
Of course.
But, right, and with the annual, and I think I have an example somewhere.
I get paid to give speeches.
And
But in that case, if you're paid to give speeches,
Yeah.
I mean, if it's not related to activities on the
Doesn't
board.
say that in here.
doesn't say that in here at all.
Really?
We're gonna have to do it for free now.
You have Bill Clinton and Bush and Obama.
Well, I don't make any
Once you
speeches
leave
on
office, but
to
you,
my kids, but.
and we'll get to the honorary in a second, but yeah, there is you can't get paid to give speeches.
Really?
We'll go into it in a little more detail. A local official receives a gift from a gift giver in October 2016 that's just under the gift limit. I have it $465.
So even if the speech has nothing to do with your position and nothing to do with,
The official, we'll get into that section in a second, it's next up, I think. The official receives a gift of similar value from the same person in January 2017. The gift giver then seeks a permit approval before the official's agency in March of 2017. There are two things to worry about in this situation in terms of the gift limit amount. First, an official may not exceed the gift limit in a given year. This official has not exceeded the amount in either year. The second thing to worry about is whether one has exceeded the gift limit in a 12-month preceding a decision involving a gift giver. When this happens, the official must disqualify himself or herself from participating in a permit. So you have a regular calendar year limit, but then you also have the limit of within the last 12 months prior to the decision being heard or the issue being heard before you. So you have to look at both. Consequences of disregarding gift rules. Those who disregard the gift limit and reporting requirements face a penalty of administrative sanctions up to $5,000 per violation, civil penalties up to 3 times the amount of the unlawful gift. They also face the prospect of hiring an attorney at their own expense to help them navigate the FPPC enforcement process. If the enforcement effort occurs through a private lawsuit, the public official may have to pay the attorney's fees of the person who brought the action.
No, I don't make any speeches, but is there, let's say that Julie does get an opportunity, could she come and talk to you about whether or not that's gonna interfere?
Yeah.
Okay.
Yeah. Always free, and we'll get into the honorary in I think a couple slides. And then best practices, decide whether and the extent to which you want to accept gifts. If you decide to accept gifts, develop a tracking system to enable you to. Determine whether and how much to report on your statement of economic interest, and threshold anything 50 or more from a single source over a calendar year. Avoid exceeding the annual gift limit, $470. Know when you need to disqualify yourself in matters involving a person who has given you $470 in gifts over the preceding 12 months. Know what kind of gifts are prohibited, not just limited. Prohibited gifts includes gifts for transportation companies and in most instances, speaking engagements.
so I have a question. My very first year when we first started as a board, we were invited to some shindig at a winery where elected people, they invited all the elected people, I mean city council, board of supervisors, different districts. And as an elected person, you didn't have to buy your $30 ticket to be there. So would that be
That's a
considered a $30 gift
Yeah.
and you would count that towards your
Yes.
annual? Okay.
Honorea ban. Honorea ban prohibits most public officials and all candidates for public office from accepting an honorary. Under area are payments made to an official from other than the official's public employer for making speeches, publishing articles, or attending public or private conferences, conventions, meetings, social events, meals, or like gatherings. I haven't seen anything that talks about that has to relate to your position, but I can look into that. I've never really looked at that issue in depth.
Would it also have to be something that somebody would observe and find that it was a conflict of interest, and then that's what creates the initiative for it to become a Brown Act violation?
No, we're also Brown Act. This is on ethics, and and it's not that somebody observes it. Yeah, somebody could find out about it, and also everyone's required to fill out and complete a Form 700 every year,
Right.
and so that has to be on it. And if it's in excess, they're open to the public, and the public can look at it and go, "Oh, it got too much." Or if you didn't disclose it, which is worse, and somebody knows that you got this gift or honorary, and they challenge you on that.
But I'm attending a conference, but I'm paying for it. So that doesn't
Right.
fall here, because you're not, the board's
Right.
not paying for me to go,
And are you right?
right?
Are you getting paid for giving a speech?
I do occasionally, yeah.
Then I need to look into that. I don't, like I said, I don't know
Not right now, but
right off if it includes anything that has nothing to do with the sanitation district. Any issues, if you can go out and, give a paid speech on some other issue completely unrelated to this and related to your work. Misuse of public funds. The starting point for an analysis concerning the misuse of public funds begins with the principle that public funds must be expended for an authorized public purpose. An expenditure is made for a public purpose when its purpose is to benefit the public interest rather than the private individuals or private parties' purposes. In People versus Batten, the county supervisor uses county compensated staff to work on his political campaign for lieutenant governor. In People versus Harvey, a city official used a city car entrusted to him for use in connection with official business to take a pleasure trip from Los Angeles to Great Falls, Montana, and back.
That first one happens all the time in like Congress and stuff.
Kendall Smith used a county car for her personal and had to pay it back.
Oh, yeah, I remember that. Yeah.
Right. And it's something you have to pay attention to, and, just because you have access to it doesn't mean you can use it for your own use. That includes copiers or anything else that belongs to the entity. You can't just come in and say, "Oh, I want to print 100 flyers for my kid's baseball team." It's like, no, you can't. You take it to a copy place and run it off. State auditor on Thursday blasted various California agencies for ethics violation and wasteful practices, including the failure to collect nearly $315,000 in rent and utilities over 5 years from tenants of a mobile home park owned by Caltrans. They also found a district engineer for the State Water Resources Control Board violated conflict of interest laws by repeatedly recommending that the state's drinking water program enter into funding agreements with an engineering firm that employed the district engineer's spouse, and by proving the engineer firm's claim for payment. The firm received $3.9 million. And that is, a lot. A police officer supervisor working for the Department of Parks and Recreation improperly accepted a gift of 24 pair of designer sunglasses valued at $4,800 from a vendor that did business with the state. And the Department of Public Health wasted $74,200 in state funds by inappropriately reimbursing the commuting expenses of an official from the official's home in Sonoma County to headquarters in Sacramento. These things happen all the time. And that's the end of the PowerPoint. Take a break. and then
24
come back
pairs
to-
of sunglasses. Who
So,
needs more than two?
One thing I want to follow up on the ethics issue, penalties for not disqualifying oneself when you have a conflict of interest. The decision could be invalidated, the offense can be prosecuted as a misdemeanor, conviction could result in official being removed from the office. In many cases, the official faces having to personally pay fines up to $5,000 and $10,000 per offense, among other possible penalties. The official also faces having to hire an attorney to defend him or herself. Also, if the action to enforce the conflict of interest clause is brought by a private individual, and that individual wins, the official may have to pay the individual's attorney's fees. There is also the personal and political embarrassment factor associated with being accused or found guilty of violating ethics laws. So that's, like I said, it's only the individual as a conflict who can actually declare that they have a conflict. Nobody can force them to, but these are fairly serious consequences if you fail to declare a conflict when you actually have one.
What you just read, is that in here?
Yeah.
Yes,
Seven.
that's 7.
7?
Absent.
And then for the misuse of public funds and the consequences of violations, misuse of public resources for personal or political purposes is punishable by civil penalties up to $1,000 a day plus 3 times the value of the resource used. Criminal penalties including a 2 to 4 year prison term and being disqualified from holding public office, prosecution for income tax evasion with associated penalties under federal law, administrative or civil penalties under the Political Reform Act for failure to report the value of the misused resources as a campaign contribution if the official is running for office.
What page was that?
That's not in there.
Ah.
That's just my own notes.
So are we on section 2 now?
Well, that was all that's covered in it. We can get the conflict of interest rules, and this is just more specifically spells out some of the rules for conflicts of interest. And I just thought it would be something handy for the directors to have to look at if they want to, if they have a question themselves and they want to look at something. And then tab 3 goes into recent changes to the Political Reform Act. It talks about some changes that have been made, nothing earth-shattering. Nothing that jumped out at me that would be very relevant to this board at this time. And then there is one, local post-employment restrictions. Current rules prohibit for a period of 1 year after the official leaves office, elected and others specified local officials who held positions with the local government agency from acting as agents or attorneys for otherwise representing for compensation any other person by appearing before or communicating with the local government agency or any committee, subcommittee, or present member of that local government agency. This bill would specify that the 1 year prohibition applies to independent contractors of the local government agency or a public agency or appearing and communicating on behalf of that agency.
And also, it applies to lobbyists?
There's a separate one for lobbyists.
Okay. Because I've seen people get in trouble for lobbyists.
Yes. Okay. And tab 4 is something I wanted to draw all of your attention to, is the conflict of interest for the Ukiah Sanitation District. And it was adopted adopted in 1998 by the Board of Directors of Ukiah Valley Sanitation District, at that point the dependent board.
Any idea who they were?
Who the board members were?
In 98, any idea who that would have been?
Two, I don't know the supervisor or the two supervisors or city council members who were on at that time, for my time here.
Just curious.
And it says, in Appendix A, which is page 7, lists designated positions, and it designates all directors of the sanitation district, district manager, district executive officer, district engineer, and then consultants. So disclosure categories for the above designated positions include all sources of income, interest in real property, investments in business positions, and business entities.
And I think it's also, they, like my position or any of these others that are named, they also fall under that 1 year.
Of appearing, yes.
Right. Okay, that's what my understanding is.
Yes, district managers, CEOs.
Yeah.
Seven we've been over.
Where are we now?
Six and seven we've been over. And 8. And penalties for being on both sides of a contract.
What number is that one?
That is number 8. And agreement, and that's if you're voting for a contract as part of a public entity, but you have an interest in the contract.
And you don't,
And you don't disclose it.
you don't disclose your conflict.
Right,
Got it.
and you don't accuse yourself. The agreement is invalid. This means that the offending official won't be paid for whatever goods, services, or property that were provided under the agreement. Violation of the prohibition against having an interest in a contract can be prosecuted as a felony, which can result in fines, imprisonment, and loss of office. And number 9 is simply the regulation that talks about
So
legally required.
I think both sides of the contract was a City of Val issue too. Or the city manager and his staff were giving themselves
Raises.
increases and all that stuff.
Yes.
Okay.
And I believe that resulted in the decision to say that you can only give raises at regular meetings, not special meetings.
And, well, it wasn't raises, it was any compensation, right?
But
You
Right,
can,
any
you can have
compensation,
special
right.
meetings to terminate or to do whatever you want as long as compensation.
compensations,
Yeah,
right.
yeah, so, it doesn't have to be, just raises, it can be discussing any compensation that they might get in the next year.
Right.
Right.
And then number 10 and 11 are two of my favorite issues. Public Records Act request.
That had to be sarcasm.
No,
Oh, yeah.
and 6253, which is the first one, just talks about the timeline and what you have to do when you get a Public Records Act request. And the request does not have to be in writing. My preference and instructions to people is always try to get it in writing if you can, because then you know specifically what they're asking for. And if they call you up and just want to give you it over the phone, get an email address and we confirm it back to them. This is what you requested. Just want to make sure.
Well, quite honestly, I would just refer them to the director.
Right. No,
Yeah.
right. Generally, these things aren't going to come up
Right.
to the directors themselves, the district manager
Right.
or the administrative assistant
Right.
are the ones who are usually going to get this. But just so if, some of your constituents come up and say, I made a Public Records Act request and they wanted me to put it in writing. It's like, well, we request. We don't, never demand that they put it in writing. Just like Mr. Howard said, we can't require him to state his name. No, we can't. We can ask him to state his name, and the purpose of stating a name is so that for the record, for the minutes, we can have it accurate that this is a person who spoke. We can ask if they put it in writing, and you're required, if you have it immediately, if it's a document that the entity has, you can just copy it and give it to them, you can charge them. You can only charge for the actual cost of copying and the time of the employee standing in front of the copy machine doing the copying. You cannot charge the citizen for the time it takes to locate the documents or get them together or anything like that. It's just simply whatever the cost is for copying and the time of the employee who's doing it.
Have we charged?
I was just gonna say, have we ever charged for that?
We haven't since I've been here, but I've only
No.
been here for 7 months.
I don't think so.
Yeah,
It just
okay.
depends on how voluminous
Yeah.
it is.
Yeah.
And then with everything on computers, a lot of times we'll just simply tell them to give us a flash drive, we'll put it on a flash drive and give it to you. It's easier that way. You have 10 days to respond. It's not 10 days to give them the documents, it's 10 days to give them a response stating, we've located documents, or we haven't located any documents, or, we've located some, but we think they're privileged. There's also a 14-day extension period that you're allowed to take. But there's fairly specific, 4 specific reasons that you're allowed to get that 14-day extension. Need to research for and collect the requested records from field facilities or other establishments that are separate from the office processing the request. Need to search for, collect, and appropriately examine the voluminous amount of separate and distinct records that are demanded in a single request. The need for consultation, which shall be conducted with all practical speed with another agency having substantial interest in the determination of the request, or among 2 or more components of the agency having substantial subject matter therein. And 4, the need to compile data into right programming language or a program to construct a computer report to extract data.
I think we had something like this when Frank was director and Vichy Frank was requesting some information. No?
I don't remember that. I mean,
I have a question, different nature of a question. I'm talking about everything, ethics, Brown Act, meeting notices, and all of that stuff. You had made the comment, Lee had made the comment that most of these agencies in Ukiah or in Mendocino County don't have attorneys.
Right.
Okay, we have them.
right.
So if the district if the district gets legal counsel to advise the board as to, okay, you're okay with this, but you can't do this, and we get, somebody files a suit, or we get a complaint that we violated a Brown Act or something, what's this group's exposure versus the attorney who advises?
Right. There are some provisions, especially relating to the ethics rules, that simply saying my attorney said it was okay is not okay. It doesn't protect you.
Well, of course.
Well, that's my question, so.
That's why you contact the FPPC or your
Who makes
private
these rules?
or your private counsel to get in. And that's why it's just, we advise. I mean, my position always has been, I advise. This is my opinion. I think you have a conflict. If you don't think you have a conflict,
Yeah, the reason I ask is well, other than the new board members, I'm the newest person in the district, so my experience so far with the district is when Ronco was the chair, was, okay, this, and this. Okay, if the attorneys say if you can do this and that, that's what the board did. I don't ever remember, well, I can't, not before me, but during all the time I'm here, that was the kind of default position, I'll just say that.
yeah. And for, like I said, for Brown Act violations, if there is a violation of the Brown Act, then it's against the board itself, generally not against an individual member unless it is serial meetings.
I got you, okay.
And so that would be on the attorney, but the ethics portion, I've never told a elected official what to do. I've
Right.
always said, maybe, I don't think so, but it's, and I always say, it's your decision because you're the one who could get sued for it, or could be held liable for it.
I should have been.
And so then back to the Public Records Act request, you have the 14-day extension, and then there's a lot of exemptions, and that's under 6254. 3-4 pages of exemptions of different kinds of records that are exempt from disclosure.
What
And
tab was that?
you have to, that's number 11.
Yeah.
You have to look through it carefully and determine, does it fall within any of these? You know, and the one thing, not so often here, but personal information, social security numbers, date of birth, in some instances, actual billing amounts could be considered confidential, or other things. It just depends on what you're looking at. Billing records for a period of time can be considered personal, and you can't get that out.
About, like, property records
They have their own, yeah, they have their own rules of what they can give out. The clerk recorder, they have very specific rules as to what they're allowed to give out and not give out as far as property records.
Because we get into this all the time with people who are delinquent in their bill, you know what I mean?
Right,
Because we have the annual meeting where we have the delinquent rolls,
right.
and as people start talking about people's property, right?
Yeah.
Oh yeah, that's always public at the meetings too.
Yeah.
All the addresses and names of everyone who's delinquent.
Yeah, I'm just thinking of the property owners who call us and
But
say,
we're required to do
their
that.
tenant has skipped town and they've left them a $2,000 bill, and it's,
Yeah.
sorry.
And, let's see.
Where are we now?
And I'm pretty much through with the envelope, with the notebook.
We don't,
And,
Yeah.
oh, we did 12.
well, 12 is
Yeah,
nice.
12 is
the best
pretty easy.
chapter here.
Well, that's the one
Almost
where I was
13, 14, 12, 50.
And,
No, as the
okay. Okay, but, you know, one of the main points, and I've made it several times, is, especially with the ethics rules, the ethic rules are the floor, not the ceiling. You know, ask yourself these kind of questions. What decision, behavior, or course of action will best promote the public's trust in my leadership and that of my agency? Would I want to read about a certain course of action on the front page of my local newspaper? How do I want to be remembered as a public official? What would make my family and parents proud as a legacy? And even if your agency attorney has advised you that a particular course of action is legal, your analysis as a public official isn't over. You need to, you know, ask yourself whether merely being legal or meeting the law's minimum requirements is what you want, what you want to do. Any questions? Comments?
I'm just gonna call it legal.
And the,
Are doing anything?
you know, and the one thing I wanted to say to all the board members is, if you have questions about this stuff, give me a call. I mean, that's what I'm here for. Give me a call. If you think something's not right as far as the Brown Act, or you think you have an ethics issue, or anything else comes up, call us. Because that, you know, being proactive and calling them, and I believe Mr. Whip said that about when he contacted Mr. Howard, if you think you're gonna have a problem, get out in front of it. Contact people and say, okay, this might be an issue, how do we deal with it?
I talked to County Council, Kit Elliott. She's gonna be teaching this class for all small boards at LAFCO
Yeah.
in January. She said that we're welcome to go, and she said that we could call her with any questions, and she says she's an expert on the Brown Act.
So it is required, this training. What's the frequency that you're?
Every 2 years.
Every 2 years.
Well, she's doing it in Jan. Yeah, I was gonna.
And as a LAFCO member, we do try to put that, because LAFCO exists on money from all the district cities
Yep.
that contribute to it. So LAFCO does try to put on Brown Act training that everyone can attend. They had one about 6 months ago, but I wasn't able to go to it. It was like in the middle of the day.
Well, she's doing it in January.
Yeah.
Yeah. She's gonna teach.
And I think the first Brown Act training I had,
Yeah.
you might have done too.
I did LAFCO.
Yeah.
I used to do them for the county all the time.
Because you were working for the county when I was on this board, and then Janine actually, I think, might have done one of ours as well.
Yeah. Any other questions? All right, I'll find
So my
these
point is, you don't have
certificates.
to go to that, you don't have to sit through this again if you don't want to, but you're more than welcome to.
Yeah, it's pretty much the same as mine. I mean, I know they use mine as a basis, but I've never changed it since I constructed it several years ago.
Can we talk about, the agenda for the next meeting, or things that we want to add to the agenda before we adjourn?
What's the best way to do that? Generally, it would be talking with him and her about what's gonna be on the agenda. We can, so the next meeting is December 13th, Wednesday, correct? That's what we voted on.
To answer Julie's question, and I'm not saying it's happened here, but my past experiences led me to, I kind of collect all of the requests from the board, and then funnel those to the chair, and give the chair the prerogative of saying now, or if we've already got a plan to do something that maybe the next meeting, if somebody has it requested for a specific rate, we just need to know. And so it might be easier to get a hold of me during the week through email here at the district, and then I can funnel those to the chair, so that it's all coming into one clearinghouse.
Yeah. And my concern about discussing it in a meeting like this at this point is it's too easy to get into the actual subject of what you want to have on the agenda. And it's easier to avoid that if it's just an email to the district manager, who will then put them all together and give them to the chair and make the agenda.
And by the way, don't anybody misinterpret this, I'm not a filter for stuff that comes in, I'm just a collector. The filter is you all, not me. I don't create policy, you all do, I just implement what your desires are.
So it's not a Brown Act violation if I send an email to them, I'm just stating what I want on the agenda, so that they know, they don't repeat to you, or, so that they know what I'm asking to be put on the agenda. As long as they.
It's probably strictly not. I would be careful though, and just simply because
They
they
don't
can.
answer me back. They don't send an email back saying, well, why don't you change the word? I mean, then they're starting to discuss
Right.
it, but I can send it out to them.
And say, because generally the exception built into the Brown Act is for scheduling a special meeting. And generally special meetings are on one or two topics. It doesn't always hold that way. The communicating about, I'm gonna have this on the, I'm gonna have this on,
I'm gonna
I want this
request
on agenda.
For a regular meeting.
That can generally, like, and I believe what happened with the accounting, that's one I'm most familiar with, is the requests go to the CEO, who then puts the agenda together, and then the CEO and the chair, and usually county council will sit down and go over it and look at how they want to organize it and how they want it to go on. But generally, all of it can go on at any point. Anything you want is allowed to go on the agenda.
And Julie, your question's actually really a good one. Because yeah, what's wrong with bringing it up right here and right now? But like Doug said, because pretty soon your comment prompts my comment and then her comment. Next thing you know, we do have this little mini meeting without it being actually on an agenda for public awareness. So, yeah, it's tough. You're never quite sure where you're gonna step into
You
this.
just have to
rabbit.
remember not to comment on it. I mean, I'm gonna tell them what I want.
For some people, that's harder.
Easier said than done.
Exactly.
It could be the comment, could be, yeah, I'd like to do
You
that
can talk
because.
about that next week.
No, I mean, Julie's point is a good one, because if somebody writes me an email and says, I've not only had emails, but I've had phone calls, where a voice message is left after hours on the phone and says, Joe, please inform the chair I would like this on the next meeting. Thank you very much. So they didn't discuss it, they didn't give me why, they just said, here's the item, put it on I pass it on to the chair, and that's, I would do that with your email.
And
I don't really care what the subject is, because it's not for me to say no, it's for you all to do that, and I simply pass on the information.
John has something to say.
It's not uncommon nor illegal at a board meeting,
The end of the
at a
board.
Brown Act qualified meeting, for something to come up that is prompted from another, and the chair says, let's make sure we get that on the agenda if it's a request. And then everyone usually knows not to discuss it.
Yeah.
But it is,
Gotcha.
it's a perfectly appropriate and absolutely common method in getting an item on the agenda that comes up.
So, going back to her question there, she has something she specifically
I
wants.
have two somethings.
Okay. Is that a problem with her bringing that up now, or would it, as you recommended, go through, the district manager?
And, I mean, you can bring it up now. I just said my preference, and I think the safer way to avoid
A discussion?
any discussion is doing it in writing or by a phone message. But if you want to bring it up and make sure that both of them know what you want on the agenda, I think.
So,
It was just an item, and we're not
Right,
discussing it.
right.
yeah,
But
don't
you
say
can't-
anything.
Damn, don't make me say anything, Julie.
No, don't say a word. I've got two items I want on the agenda for next week's regular meeting.
Okay, just say it, what are they?
Which is the 13th.
Is
Right.
that next week?
And
Next
six,
Wednesday.
6 p.m.
Yeah.
Yes. Okay.
Okay, so I want a discussion and possible action on the severance package for District Manager Joe Tate that was decided in a special meeting held November 30th. Period, that's that one.
Instead of severance package, could we just say entire contract? Which would include severance and everything else in his contract?
Sure.
Okay, thanks. Just an idea. Okay, you got that then?
Yep.
And what else?
And the other one was, an agenda item discussing provisions and payment of an attorney that, of our attorneys that are at regular scheduled meetings or special meetings not pertaining to the current lawsuit or mandatory January settlement conference. I'd like to talk about having an attorney present at every meeting. And if that's needed, if that's necessary, and how much it costs us to have an attorney at every meeting, and,
Can Julie, I've worded it as discussing.
no discussion.
Discussing provisions of having attorneys at every meeting.
Yeah,
Okay.
no, yeah.
Okay. Good.
That's good, that's what.
I don't want to point out the obvious again, but since you changed your meeting to Wednesday, you're kind of under the gun to get the agenda out.
Yes, we are.
Yeah, that's
Right.
kind of what I
Friday.
wanted to do.
Yeah.
Or Sunday. Sunday's technically 72 hours in advance.
Saturday, Wednesday's the 13th?
Yeah. Is it Saturday, then it's Saturday? I thought it was.
Saturday's probably safe.
Yeah, but it's 72 hours, not
Yeah, it's 72 hours period, yes.
weekends, holidays, doesn't matter.
While we're here, is
Right.
there anything else anyone wants on this next agenda? Because of the timeline, we're gonna have to get it out. Is there anything else? No? Okay. If you think of anything in the next 24 hours,
I'm sure it'll come to me in the middle of the night.
Yeah, exactly. I'll joke.
I'll email you guys.
So, we're done with our training and can we adjourn now? Are we done?
Yes, we can,
Okay,
yes,
so we're
that's it.
adjourning at 8:26 PM.
8:26.
It's not bad. Not bad. Good.
Now, are these, the
They're yours.
district?
They're yours.